Stephanie Klein of the Robert Allen Law Firm. You may notice that they're one of our major sponsors here today. Robert Allen Law Firm is a full-service boutique law firm with offices in Miami, Fort Lauderdale, Palm Beach, and New York City. And Stephanie focuses her practice on yacht transactions, advising yacht manufacturers, dealers, and brokers on general business matters, as well as private buyers and sellers in the purchase of sale and new and brokerage vessels. Robert Allen Law regularly advises yacht owners, buyers, sellers, brokers, and lenders on all aspects of yacht transactions, including chartering and the purchase and sale of luxury yachts. Ladies and gentlemen, Stephanie Klein.
Hello, everyone. All right, so let's see if my clicker works. It's not working. Oh, there we go. Okay, so as you can tell from looking at your brochure and from here, I am going to talk about contracts, your charter contracts, cancellations, and your commissions. Okay, so this presentation is divided into 3 parts. Number 1, we're going to talk about what happens when you have a contract and the owner cancels. Do you get your commission? Number 2, we're going to talk about what happens when you have a contract and the charterer cancels. And again, do I get my commission? And number 3, we're going to talk about what happens when you have a charter contract and the vessel is sold. And as you all still want to know, am I going to get my commission? All right, so in the context of this presentation, we are going to talk about 3 agreements, really 2 of them. You guys have the amoeba charter agreement, you have the 2 AYCA agreements. I think you're mostly using the amoeba charter agreement and probably the AYCA recreational bareboat. So that's going to be the focus of this presentation. The vessel services agreement, I think it's probably not used as much. I'll point out here and there where maybe there's some differences or pointers, but it's not going to be a focus. So just so you guys have a little bit of context for what's going on. So let's get started. Okay, let's talk about what happens when the owner cancels. This is the language in the amoeba on top, and this is the language in the AYCA bareboat agreement on the bottom. The amoeba, it's pretty short and sweet. I'm not going to read this because honestly, when I start reading these, I get like 2 lines in, and I'm like, oh, I've got to start over because it's not fun. It's pretty boring. So what I'm going to do for you guys is tell you on a very practical level what this means. So if prior to commencement of the charter, the owner tenders notice of cancellation via the broker, there's two scenarios here, 2 things that can happen. So if the owner's canceling by reason of force majeure, and I think most of you probably know what force majeure is. We talked about it in the last charter seminar, but if for some reason you don't, this is things like acts of God, war, strikes, hurricanes, forces of nature. If the owner has to cancel, he has to, he doesn't have a choice, there was a hurricane, what happens? The charterer is entitled to immediate repayment of all of the payments made. End of story, right? The second scenario is what you're going to run into more often. Any other reason other than force majeure. What happens when the owner just cancels? Doesn't matter what the reason is. The charterer is still entitled to immediate repayment of all of the money that he's paid, plus liquidated damages based on this schedule right here. And you can take a look at the schedule in the agreement yourself. To sum it up, if the owner cancels 30 days or more before the commencement, he owes 25% of the charter fee. More than 14 days, but less than 30, he owes 35% of the charter fee. If he cancels 14 days or less before the commencement of the charter, he owes 50% of the charter fee. So let's talk about a few of the things that are going on here, right? Notice. You may be wondering, well, what is notice? It sounds self-explanatory, but it's actually very particular. And the contract specifies, both contracts, both the amoeba and the AYCA, exactly how notice has to be given. It must be in writing. That means it can be by letter, it can be by fax, it can be by an email. Arguably, maybe even a text message. That's writing, right? We get creative. It's, new age. People are texting and whatnot. Generally, the notices are considered given when they're sent and when they have proved to dispatched. So if you're sending a letter, best practice is always you send it U.S. certified mail, return receipt requested. That's, just a tip when you're sending out paper letters. And the contract goes on to say, if you're giving notice to the owner, you can give it to his address in the agreement or to the broker. If it's to the charter, same thing, to his address in the agreement, but you can also give it to him on board the vessel. Obviously, that's when the charter is taking place. All right, let's talk a little bit about this liquidated damages thing, because that's a legal term, right? I don't know if you guys know what liquidated damages are. I'm going to tell you, but it's a big legal word that isn't that self-explanatory. Lawyers use it, they put it in contracts when injury is hard to determine or difficult to quantify. So if you're a charter and it's a week before your vacation and you've flown in your family and you're waiting, you're going to get on the charter, it's going to be great vacation, everybody's happy, but the owner cancels, how do you determine what your damages are? There's going to be some quantifiable damages. I bought a flight, I did this, I did that. But how do you quantify the inconvenience to that person? It's hard. So that's why the contract puts, these percentages, 25, 35, 50%. It's not a penalty. It's not to penalize the owner for canceling. And why is that important? It's important because in the U.S., we have lawyers, have very specific language under the law that they have to include to make these liquidated damages viable, or if you go to court for the judge to say, okay, I'm gonna give this to you, right? And the MEBA agreement is subject to English law, right? That's not U.S. law. So they don't have these magic words or magic language. The AYCA does because it is subject to U.S. law. I'm not going to read that to you. It's boring. But I will tell you that the MEBA and the AYCA both say if the owner has to pay liquidated damages, they're due immediately. Immediately. But how do you get the owner to pay? Do you think an owner who's canceled a charter a week before the charter's vacation is just going to come out of pocket 50% of the charter fee and say, here you go, I'm happy to write you a check? Probably not. Probably not, right? How do you get the owner to pay? You're going to have to go through a lot of time, expense, probably headache, chasing this person, get a lawyer to send a scary lawyer letter that says, hey, if you don't pay, I'm going to sue you. Maybe you have to sue him. Depends on how much money we're talking about, right? Is it worth it? The good thing, though, is that there's an attorney's fee provision. You get attorney's fees, the prevailing party. So if you're in the right, the owner, if you're the charter, the owner really screwed you over right before your vacation. You did nothing, you're owed 50% of damages, you have to get a lawyer and go through the process. The owner's going to pay the charter's legal fees to do that. All right, commission. That's what you guys care about, I know, right? So, MEBA and the AYCA bareboat. Basically the same in terms of how your commission is deemed earned, but there's a subtle difference. So under MEBA, it's deemed earned upon the signature of the agreement by both parties and payment of the deposit funds by the charter. AYCA, very similar, deemed earned upon signature of the agreement by both parties and broker's receipt of charter's initial deposit and cleared funds. Now, payment of the deposit and receipt of charter's initial deposit, they're probably going to happen simultaneously, right? You pay and the broker receives. But you could be in a situation where that's not the case. You never know. Just something to keep in mind. Very subtle difference. Just keep it in mind. The commission is payable whether or not the owner defaults for any reason, including force majeure. That's important for you guys to know. If you meet this up here, the agreement's signed, the deposit has been paid, the broker's received the funds, the owner is liable for your commission. What happens when the owner cancels? You do not deduct your commission out of the deposit. In this case, you have to give that money back. If you're the stakeholder, you have to give that money back to the charter. It's the charter's money. You have a claim against the owner for your commission. But then we go back to what we just talked about. How are we going to get this guy to pay? Maybe he'll be nice. Maybe he'll cut a check for 50% in liquidated damages, give it to the charter, cut you your check for your commission, and walk away. That's a perfect world. I like to think we live in a perfect world, but it doesn't always work out that way. All right, so that was all very fun, but also very boring, I understand. It's contracts and it's the law. Let's look at an example. Hopefully this will be a little bit better. All right, so you are, in this example, you're going to serve as the charter manager and the charter broker. You're playing both roles. You represent an owner. He has this boat. For this example, it's called MY Big Red. Your owner signs an agreement with your charter. Her name is HC. July 1st, they sign the charter agreement. July 5th, the first installment's due. September 1, second installment due. The charter is going to take place in the Bahamas from October 1st to the 8th. Now, here's your guys. August 1st, 2 months before the charter is supposed to commence. Your charter, DT, he calls up, or excuse me, your owner, DT, calls up charter. He says, I know I said this charter was going to be the best, the greatest charter in the world, but I don't think I'm going to be able to do it. I've got some business down in Mexico, and I think I'm going to ride my boat down there. Just saying. She says, all right, you know, whatever, I hear you. Nothing really comes of it. But September 1st comes, and the second installment is due, and she pays it. September 28th comes. It's less than a week before the charter. And now he sends, your owner sends formal notice. That's you down there, you're the broker, holding the letter, you get it, you give it to her. She looks very disappointed reading it. Oh, maybe he was serious. I'm about to go on vacation, I have my bags packed, and now my boat's not there, right? Oh. Tensions are high. You're stressed. There might be a fight. There probably will be a fight. You're pulling your hair out. I know. What do you do? If you don't know what to do, hopefully after this presentation you'll know what to do, but if you don't, call your lawyer, obviously. All right. So let's talk about this. Can the owner cancel? Is his personal decision that he wants to take his boat to Mexico enough? Yes. Yes, you're right. It's any reason. Any reason at all. That's what the contract says. What does the charterer get? She gets the full refund of all amounts plus liquidated damages. How much in liquidated damages? Well, when's our timeline? Are we counting off of the August 19th phone call? No, we are not. What does the agreement say? It says in writing to your broker. So are we going off of the September 28th letter? Yes. How much does he owe? 50% of the charter fee. Now, is DT a man of his word? Is he going to cut a check? I don't know. We'll see. Maybe you have to go after him. Probably will. This is your importance of written notice. Do you get your commission? Yes. The owner owes you. You don't get to take it out of the amount that the charterer paid. You have to go after DT and say, you owe me my commission, pay it, don't make me have to come after you. Will the owner pay? We covered that. Is there an obligation to find a replacement? You guys probably know that there's this language floating around in the agreements that says mitigation of damages. Find a replacement. You know that's somewhere in the agreement. It doesn't apply here. We'll talk about it and where it applies and how it applies, but it's not in this case. So when there's cancellation by the owner, there's not an obligation to find a replacement. And what can I say? That's that. All right, so this should actually say cancellation by owner. We're going to change the scenario really quick. What if the owner changes the cruising region? Now that's not a cancellation, but he calls up and he says, I know that this cruise is taking place in the Bahamas, but I'm moving the boat up to Alaska, so you're going to have your charter in Alaska now. That's a breach of a material term in the contract. the owner can't do that, right? That's going to lead to a cancellation. You're going to look at these rules that we just talked about. All right, so summary of that. Owner can cancel for any reason. It's really harsh on the charter, actually, when you think about it. The owner has this unlimited license to opt out, and he can limit his damages, by looking at, how much he's going to owe under liquidated damages. Owner's still responsible for your commission, and you may have to chase him down to get paid. All right, so let's switch gears. Let's flip the situation. We're going to talk about cancellation by the charterer. Now, what we just talked about, we kind of lumped in the MIBA and the AYCA together because they're very similar. They may be written differently, but the heart of the provision is the same effect. Not so much the case with cancellation by the charter. So let's talk about MIBA first. It's clause 11. That's the whole thing. That's a lot of words going on right there. But I'm going to tell you what it says in plain English. If the charterer gives notice of cancellation before the commencement of the charter, the owner retains the fee as follows. The owner will always retain the first payment and any installments due and paid. If an installment is due and not paid, the owner has a claim over that amount. The first deposit is always non-refundable. Think of it that way. These are some easy ways to think of that really long paragraph in the contract. Again, no particular reason is required for cancellation. So your charter gets sick, like really sick, an unfortunate event happens and he has to say, I can't take this vacation, I have to cancel. I'm sorry, there's not a nice, provision in this contract to say, I'm sorry, we feel bad for you, it's not your fault. Any reason for cancellation, you're subject to these rules. In the MIBA, and this is where the MIBA and the AYCA differ, there is no reference to the charterer canceling before any installments have been paid. And that's unlikely, right? It's unlikely that someone's going to sign an agreement and then say, I changed my mind 2 days later and I don't want to pay the first installment. It might happen. But under MIBA, the payment of that deposit or first installment is an essential term of the contract. It's what lawyers like to call consideration. You have to have it to have a valid contract. So no deposit, no contract. And if any of you guys are brokers in the sense of buying, representing clients buying and selling boats, and you've been to the other EBA presentations, you've probably heard in the EBA purchase and sale agreement that there is language in there that says no deposit, no contract. And that's true, but it's not true here. So be careful, understand your agreements. Let's move on to the AYCA bareboat. Again, there's a lot of words going on right there. This is what it says in simple terms. If the charterer cancels after the agreement is signed, but before the first installment is due, the charterer will pay and owner may retain the first installment. That's the major difference here. And this is similar language to what I was talking about in the EBA purchase and sale agreement. This says no deposit, no, that's MIBA. This says you can't sign and not pay and just walk away. So if you're using AYCA and you tell your client, sign this, he better be ready to put money down. That's what that means. And then the second prong here is similar to MIBA. If the charterer cancels after the first installment is due, the owner may retain that installment and any other amounts due and payable. If there's amounts that are due but haven't been paid, the charterer shall pay those amounts immediately upon cancellation. Again, we're going back to how do you get people to pay for something that they don't have money in an escrow account and you have control over it? Are they going to be nice? Are they going to say, oh, I canceled this charter, I'm not going on my vacation, but yes, I will pay you the second installment? Probably not, unless they're just really, really nice and a really good person. I don't know, maybe. Your commissions in the context of cancellation by charter. this is the good situation for you, because this is money in an escrow account, and the charterer cancels. It's money that the charterer put up. It's his fault for canceling. Your commission is considered an expense and deducted from the deposit. So this is kind of, like easy money for you, right? You're not really having to chase somebody down. Now, I will say there's a caveat here. If you're holding money, if you're the stakeholder and you're holding money in an escrow account, and there's a dispute, there's language in these contracts that say, what you have to do. You need to be careful when you're handling people's money. There's a dispute and you're holding money, you don't know what to do. Look at your agreement, call a lawyer, figure it out, talk to somebody that's been through it before. But this is the better situation because you have a higher chance of getting your commission paid here. All right. Let's talk about a few other things that are going on in that very long provision. There's a clause in here on repudiation, another legal word that lawyers use that can be confusing. So let's talk about it in terms of plain English. Repudiation is to reject something. Here it means implied cancellation. So if the charterer fails to pay after getting a written notice from the owner, then the owner can treat the agreement as repudiated and retain the full amount of all payments made and recover all sums unpaid but due. What does that mean? You have a date, your second installment is due on August 1st. It's August 3rd. The charterer hasn't paid. You better send out a written notice, if you're the owner, that says, pay me my money by X date or this is canceled. I want my money. And if that's the case, and that day comes and goes, you send out the notice, the charterer still isn't paying you, well, and by you I mean the owner, you can cancel the agreement. And so then you have to wonder, well, are we going to go back to the rules that we talked about for owner cancellation? No. It doesn't work that way. The owner, even though he's canceling in this case, still gets to keep the full amount of all payments made, and if there's payments due but not paid, he has a claim over those amounts. There's another provision in here on owner's bankruptcy. I don't want to spend a lot of time on this. It's a little bit boring. But if the owner is adjudged bankrupt or something equivalent to bankruptcy, the charterer has the option to cancel. He doesn't have to cancel, but he's given the option. And he will be returned all of his money that he has paid. So remember earlier we talked about this duty to mitigate. You guys know that this is a thing floating around. When do I have to do it? What do I have to do? Well, it's in this context, the context of cancellation by charter. So charter cancels the agreement. If the owner is able to relet the vessel, then he has to give credit to the charter for the net amount. So the concept here is that the owner can't benefit from this in the following way. He can't say, all right, you canceled your charter, but I'm going to keep your money, and I'm also going to use my boat. That's great for me. As the owner, that's great. But what does this really mean? It's a duty of the owner. So the contract says it's the owner's duty, not the broker's duty. The owner doesn't have to go above and beyond and go out and solicit and seek someone to fill that spot, but he has to act reasonably. The contract says best endeavors, not unreasonably withhold the vessel if he gets an offer. And he does have the right, if he gets an offer, to deny a charter that would be detrimental, reasonably considered detrimental to the vessel, its reputation, schedule. Under the MIBA, they throw crew in there as well. Nice to the crew. That's nice of them. If the owner does find a replacement charterer for the charter period, or if you're nice enough, because it's not your duty, but you help him out and you find someone and you've done that work, there's no additional commission to you. Just keep that in mind. So again, lots of boring stuff. Let's do another example. You still represent the owner DT. He signs a new agreement with a charter. His name is BO. On January 1, they sign the agreement. January 5th, first installment's due. March 1st, second installment is due. And the charter is going to be from April 1 to April 8th in Alaska on his boat, Big Red. All right. So January 5th, first installment's due. BO, it's him in the blue tie. He pays the installment. Everybody's friends, things are going great. But March 1st, the second installment is due. BO doesn't pay because he's thinking, maybe I don't want to do this. I heard what this guy did to my friend HC, and I don't want to ride on his boat. So on March 5th, BO gives written notice of cancellation to DT. He's upset. He was the one that canceled last time. Now he's being canceled on. He knows how it feels. Let's talk about it. Can the charterer cancel? Yes, he can. No particular reason is required. Again, I'm sorry if you get sick, you get hurt, you have a change of heart, whatever. Reason doesn't matter. You're canceling. What happens with the first installment? The owner gets to keep it. What happens with the second installment? That was due but not paid. The charter owes it and owner has a claim over it. Again, how are you going to get him to pay? Your commission, it will be deducted as an expense from the deposit. That's you. That's you getting your money. You're happy. This is the best situation. All right. What if our timeline was changed a little bit? March 1st, second installment's due, but BO doesn't pay. March 3rd, DT sends notice demanding payment. The owner says, you need to pay me. Pay me in 7 days or this thing's canceled. March 10th, owner doesn't get a response. He can cancel the whole thing and say, I'm keeping your money. That's the way it works. He treats it as repudiated. This is the repudiation example. And your commission will be paid from the deposit. Okay. Let's talk about an example for mitigating damages. The owner gets 3 offers, right? No, I mean, he gets the first offer up there. I don't have a lot to say there, but I think that you have the right to probably, he has a good reason to reject, letting the vessel to that guy. Second guy, he says, the boat's going to be in Alaska. I'm going to take it on over to Russia. No, that's not going to work. The third candidate here, he's this nice Canadian guy. He just wants to go on vacation with his family and cruise around in Alaska. That's probably going to work. You're probably going to have a hard time saying, no, that's not going to work for me. Well, why? He's doing the same stuff. It's not detrimental to the vessel in the other 2 cases, to the crew, to the schedule. All right. Let's move on and quickly talk about the sale of the vessel. The contracts say, and this is both the MEBA and the AYCA bareboat, that the owner agrees not to sell the vessel during the charter. So this is while the charterer is on the boat, having a great time on vacation, the owner can't say, sorry, just sold the boat and now somebody else owns it. The AYCA goes a little bit further and says without charterer's consent, which charterer may withhold. He's probably going to withhold it. This is a case where you're potentially looking at a lien on the vessel. That's a little bit more complicated than what we're talking about right now, but keep that in mind. The agreements say there can be an agreement to sell after the charter agreement is signed, but before commencement of the charter. However, the owner must give written notice to the charter via the broker. If it is sold, there are 2 options. Option 1, the owner can arrange for the buyer to take over the charter agreement. There's a couple ways to do this. You can assign the contract. You can do a new contract. There's no penalty against the owner in this case, and you don't get any additional commission. That's the best case scenario. Other scenario, if the buyer is unwilling or unable to fulfill the charter agreement, then we treat this as an owner cancellation, and we go back to the rules that we talked about at the very beginning in section 1. That means all sums paid due to the charter plus liquidated damages. Owner must pay full commission. They add in a little bit more here. In this case, no later than 72 hours after formal cancellation. Again, how are you going to get them to pay? You can say you owe it within 72 hours, but you need to get them to pay. And that can be tough. So that's all I have for you guys. Just a few tail-end things here, some other considerations. If you are the charter manager and you are taking listings, what does your listing agreement say? That is the agreement between you and the owner. If you have to look to the owner for payment, you probably want an airtight listing agreement. You want to cover yourself. Think about it. Think what you need in there. Have you experienced problems in the past and you think, man, I wish I had some kind of language to back me up and get me paid? Put it in your listing agreement. Think about it. You can always amend these contracts. I've talked about it before. If you have special concerns, you can stick an amendment on top to address those. And I touched on this a little bit before, disputes as to the deposit. If you are the stakeholder holding money in your escrow account, be careful, look at the contract. It has language in there as to what you do with the money. Just don't start giving it out based on who you think it goes to. Just be careful. I wish you all very good luck in your charter endeavors. Hopefully you don't have any cancellations, but if you do, you will know how to handle it. And that's all I have. Thank you guys so much.
Let's see if we, yes.
Hello. Is a first installment the same legal term as a deposit?
It's a little bit different, right? So the first installment is probably going to be a bigger sum of money. That's going to be like the first 50% of your charter fee. The deposit, if you look at the contract, it has room for a security deposit, right? That's for things like, you destroyed the dining room table while you were on my charter. What the heck? I'm going to use that money to repair that. So a lot of these terms that we're talking about now and in the language in these contracts refers to the installment, this bigger sum of money. So just if you have questions, the agreement spells it out. Look at what it refers to.
Any other questions?
Commission, as far as on the charter, if it's a 50% deposit, do you make the 50% commission or do you get the full commission?
So if you're asking, like, if they've paid 50% of the charter fee and they haven't paid anything else, and then you've got to think about, hey, I need my commission, it's your full commission, right? So it's your full commission. It doesn't matter that they've only paid 50% of the total, you get your full commission.
Often owners will take exception to that, but that's true. You'll have to come into you. Back over here, but you have a question.
If the client signs the agreement and it's been submitted to the owner for signature, but it's not been signed yet, and the client decides, for whatever reason, I can't do this, he's still obligated?
When you say client, do you mean charter?
Charter, yeah.
So you're, just to make sure I understand, the
Right.
charter signs an agreement, gives it to the owner, and the owner has not yet signed it.
Right.
Right?
Yes.
And the charter then says, I don't want to do this anymore. So you don't have a contract yet. You need both parties to sign.
Okay.
But that's an offer. Right? So if the owner signs it, you have a contract. You need to talk to someone, how do I withdraw my offer? There's a way to do that.
Yep. I'm good.
Don't they have to pay as well? You mentioned they have to have the.
So that's tied to when you earn your commission. But if you have a fully signed agreement, there should be something in there that says the initial deposit is due within X amount of days, and that's when your charter would have a fully signed agreement and paying the money.
One more question, right over here, Ann.
So how does the charter withdraw? how does the charter withdraw his offer while waiting for the owner to sign? You've got a charterer signed contract, and the owner hasn't signed. The charterer wants to cancel. How does he go about doing that?
That's tough, right? Probably you might be able to get away with a written notice. You know, a lot of these contracts, so I'll tell you this, a lot of these contracts say that the offer has to be accepted within a certain amount of days. I can tell you that the purchase and sale agreement does say this offer expires if it's not signed within 3 days or by X date. You can try to send a letter and say, I'm withdrawing this offer. You might get into a legal fight if the owner says, no, I'm signing it. You know, it depends, right? You can use your best efforts to send a letter and say, I know I made this offer, but I'm withdrawing it. See what happens. It might work, it might not. This would be a situation where you need to look at, you know, what else is going on. Talk to your lawyer.
One more question? Great. Thanks, Stephanie.
Thank you.
Stephanie, we need your mic. Diana's going to.